For nearly 100 years, suffragettes in America fought for the right to vote in an effort to alleviate their status as second-class citizens. Although activism working toward this right spanned all genders, some citizens preferred to maintain male dominance at the polls. In Fairchild versus Hughes, we'll explore whether private citizens have the ability to challenge a proposed amendment that would give women the right to vote. In 1920, 34 of the 36 states had granted women suffrage, with an additional state in the process of granting the right. Following suit, Congress proposed the 19th Amendment to the United States Constitution. This amendment would grant women across the nation the right to vote. The proposed amendment was supported by a bill that required the Attorney General to fine or imprison anyone who refused to allow women to vote. But this change was met by opposition. Prior to its ratification, a notable anti-suffragist from New York, Charles Fairchild, feared that the suffrage amendment would go against the state constitutions that limited voting rights to men, be contrary to the wishes of the qualified male voters who made those constitutions, lead to invalid elections, nearly double the costs of elections, and generally result in irreversible mischief. Seeking an injunction to prevent the amendment's ratification and the bill's enforcement, Fairchild sued United States Secretary of State Charles Hughes and the Attorney General in the Supreme Court of the District of Columbia. The Supreme Court of the District of Columbia dismissed Fairchild's claim. The Court of Appeals for the District of Columbia affirmed the trial court. Fairchild appealed to the United States Supreme Court.